Good morning, everybody, and I hope we provide some reinforcement or some information that's helpful for your business today. And if we don't answer things that are on your mind or questions you have, please, at the end of the session, let us know so that we can address what your concerns are. Our agenda for today is to talk about the California reopening, which the governor's announced for June 15th, and some of the issues that holds for employers. A brief discussion as part of the federal COVID Recovery Act, which is a cobra subsidy, which you may or may not be aware of. Then we'd like to touch briefly on the bill that the legislature passed at the end of March, extending the COVID supplemental pay for employers with 25 employees or more. Then just a note on the Federal COVID Relief Plan, ARPA, and how it affects FFCRA. And we get so many initials and different things, it gets hard to keep them straight. We'd like to talk just a little bit about vaccinations because it's becoming a very important part of the process and moving forward quickly and what it means for your company. Touch just a bit on Cal OSHA emergency COVID regs, and as part of that PPE, because the Centers for Disease Control has just announced an update on the use of N95 masks, for example. And then there's some recent litigation involving expenses of employees, some of which involved expenses of employees who were at work, and some were expenses for employees who worked from home. So this is not brand new, but hopefully it's a reminder to you of some important principles that you need to think about for your employee, your policies in your company. So starting with the what we hope is the excellent news, California governor has announced a goal of reopening for all businesses at June 15th. And of course, that's a little earlier. The president has expressed a goal of having the country open by July 4th. In California, this would move away from our current 4-tier system, which is essentially purple, red, orange, etc., and allow companies to have no limits on their customers attending their events, coming to their facilities, and so on. However, even the reopening plan by itself will not change the mandate on wearing masks, which is a California mandate to wear masks in public, the only exceptions being if you're driving alone in a vehicle, or if you're on your own home, or if you're in a private office with a closed door. We also will have the vaccination verification process going forward, and the rules on social distancing and other Cal OSHA temporary rules. And we'll touch a little more about that when we get to the Cal OSHA provision. But this is good news. It's going to mean your employees will be more and more likely to have had vaccinations, and your customers will be more and more likely to have vaccinations, and movement and doing business should improve significantly. Another area we want to talk about is part of the Federal American Rescue Plan, which subsidizes COBRA health premiums for employees who lose their group medical coverage due to COVID. Now, I don't know how many of you have had employees who've done this, but this is an important provision. COBRA premiums are to be paid by employers who are reimbursed then by the credit on the payroll tax system. So unlike a normal COBRA situation, where an employee pays the full premium for the group health plan, in this case, the employer would be making that payment for the employee. And subsidies are available for COBRA premiums between January 2021 and September 30th, 2021. So this, if you have employees who have been given a COBRA notice or who are on COBRA, and this would extend even to employees perhaps who got notice in the last part of 2020, you need to think about this, and there is an obligation to provide notice to those employees. There's a new sample notice available from the federal government. It is, as many COBRA notices are, if you've worked with them, multiple pages and complex, and has blanks that need to be filled in by an employer. So you can't just use the notice the way it's issued by the government, but it would give you a guidance and protection on meeting the notice obligations of this part of the law. So COBRA subsidies apply to employees and dependents who lost group health coverage due to involuntary termination or loss of work hours due to COVID. And that's a pretty broad description, which could cover a lot of territory. It covers people who were previously eligible from March 2019 until March 2021, as well as those who qualify now. Employers are to pay the COBRA premium for eligible employees beginning April 1, 2021, for a period ending September 30, 21. And you get the money back by a credit on your payroll taxes. So that's an issue that affects some employers, and you need to take a look at your own records to see who was given COBRA notice and who it applied to, so you can do what you are supposed to do under this provision of the federal law. We have another provision which is passed by the California legislature at the end of March, which is essentially California's version of what had been the federal FFCRA. This is a supplemental paid sick leave, and it applies only to employers with 25 or more employees. There are posters out that must be put up, and if you have more than 25 employees, they're available online, or if you need copies, send an email to us and we'll be glad to send you the source. The posters initially were issued in English. The Spanish versions are now available. So you should post whatever language is necessary for your workforce. This provision requires employers to pay up to 80 hours of sick time for employees who are eligible because they are subject to quarantine or experiencing COVID symptoms. They're caring for a family member quarantined due to COVID, or caring for a child whose school or child care is closed, but not for general because they didn't want to operate. This provision only applies if there was actually COVID on the premises, an outbreak or an occurrence at the school or child care center, in which case this benefit applies. This is not apply to those folks whose schools were closed just as part of the overall pandemic policy. Hopefully, as we move forward, more increasingly, all the school districts in the area are opening. And so the need for childcare for children whose schools have been closed will go away, we hope, very shortly. This paid sick leave also applies to people who need to go to an appointment to get their COVID vaccine or experience vaccine-related symptoms. It's been my experience that there are a number of people who have a very temporary reaction to a COVID vaccine, usually that's diminished and gone away the very next day. There are a few people who struggle for a few days, and there are some cases of people who do have some significant reaction to vaccine. Already some of our clients have had some concerns. Employees have said they want this COVID sick pay because they have a vaccine appointment and they want the day off. Well, there is no place in California where you need a full day to go to a vaccine appointment. Where you go and how long you have to travel to it and how long you're tied up is somewhat individual. But in general, people can get through arriving at a vaccine location, including in the time of signing up, standing in line, and the 15-minute wait period afterwards, in about an hour. So being generous and say there's a little travel time added to that. If employees say they need a time off for vaccine, obviously they're entitled to it and you encourage it. And say, what's your schedule and when are you coming back to work? Also, you're not automatically entitled to a day off the day after a vaccine. Many folks in planning anticipate the potential of a reaction to the vaccine and therefore kind of try to lighten their schedule so that they're not compelled to go out if they don't feel well. But an employee who just automatically says, well, I got my shot yesterday, I need to be off today, needs to be asked some questions like, okay, what are your symptoms? When did they onset? Have you taken something like Tylenol to relieve it? We'll be dealing with this COVID supplemental sick pay for time off between January 1, 2021 and September 30th. You may notice that this means this law was passed in March. It was retroactive. You have to give the benefit to employees who request the sick pay. You do not have to look up your records and see everybody who missed work since January to see if they have to go back and give them pay, but you need to be prepared. We're recommending that you have a request for COVID sick leave form, which we have samples of. So anybody who orally tells you that they needed time off or they took time off since January, have them fill out enough information so you can at least have a record of it. You want the record because you're going to be asking the government for credit on your payroll taxes. And you also want to make sure that it's an honest statement by your employees. So this supplemental paid sick leave is good for up to 80 hours if it's for the reasons that we discussed on the prior slide. Employees can request retroactive pay for any time used from January through March. For retroactive pay, if you had given them paid sick time off your paid sick leave policy or PTO or vacation policy, there'll need to be an adjustment because this supplemental paid sick leave takes precedence and is in front of, if you will, these other type of benefits. So you aren't allowed to make them exhaust their 3 days of paid sick leave for this purpose. If you did, then they need to be restored for the time and then paid out of the paid supplemental sick leave. Supplemental sick leave must be reflected on a wage statement or supplemental form. So if your payroll service or the person who does your payroll can make a specific reflection of what this paid sick leave benefit is, that's great. If they can't adjust your paid pay stub, a supplemental sheet can be given employees. And as a reminder, if you were required to be off work for COVID-related purposes by the Cal OSHA emergency regs, you can use the supplemental paid sick leave to qualify for the payment that's required otherwise under Cal OSHA. The Cal OSHA rule is standalone. It doesn't include a reimbursement from payroll taxes. So you'll definitely want to use supplemental paid sick leave if you can to get the reimbursement for any of these expenses. And once again, the rates of infection are diminishing. In California, we have about 3,000 people a day in the total state that are now every day indicating illness, and we hope it goes down dramatically from here. So hopefully we're talking about issues that are a matter of the past and not so much something you're going to have to deal with every day going forward. Just a short note that the American Recovery Act and Federal Family Coronavirus Response Act both have implications for your business. The Biden federal reform allows employees to use a voluntary pay for emergency COVID, which had been required under the FFCRA. The FFCRA expired at the end of 2020. So under federal law, this is a voluntary provision. So what you really need to think of is you're combining the aspects of the Federal Relief Act plus the California mandate if you have more than 25 employees. If you have less than 25 employees, there's no California rule requiring you to make these sick pay payments, but you still can do it voluntarily and get tax reimbursement by using the federal legal provisions. This extension essentially of the FFCRA created the possibility that somebody may have used 80 hours of sick time in 2020 and now qualify again this year for this emergency sick leave. They don't get more than 80, but they are not charged against or deducted from that 80 hours under this law from whatever they took in 2020. And once again, this is a reimbursable expense, which makes it very important. And as I said, you can essentially apply the requirements of the supplemental paid sick leave, SPSLA, which is California, to use these provisions of the federal ARPA. This American Rescue Plan Act has some other provisions. The tax credits have been extended, as we just discussed in the prior slide, until 9/30/2021. They're only available if you offer these benefits on a non-discriminatory basis. So if you're an employer that's covered by the California law, that's not a problem because you're going to be using it for employees under state law. If you're under 25 employees, then the use of this is voluntary, but needs to be uniform. As we mentioned in the previous slide, employees can get a second leave if they used the FFCRA in last year and then have need for leave again. But there's some new qualifying reasons which become critical. As employees are seeking immunization, the time they take to seek immunization, including the travel time to and from the appointment, are eligible for benefits under this law. And if they do have a reaction to the vaccination and need to have some time to recover, the recovery time is also included under this law. This law does not apply to employers who have more than 500 employees. So this is a law for employers with less than 500 employees. There are some other provisions which I think you know about under the federal Biden Reform Act. One provides continued enhanced unemployment benefits, including an additional $300 per week in addition to state benefits, and the ability to continue receiving unemployment benefits for 53 weeks after the original 24 weeks of unemployment end. And this is for coronavirus-related unemployment. So that's important for employees and for your workforce if you're not able to return them to work or operate. Let me tell you a little about vaccinations, because this is obviously now with the lifting of the age, anyone who's a workforce is, except for young children, are going to be able to get vaccinations now. And this is a time where you can make some decisions for policies for your company. What do you want to do? You can require employees to be vaccinated, with the exception of those who have disabilities that medically prevent them from being vaccinated, or those who object to vaccinations based on sincerely held religious beliefs. So for that 1/3 or whatever it is of our population who are reluctant to be vaccinated, that's not a excuse or exception if you decide as an employer to require vaccinations for employers to work. You can also require proof of vaccinations for any employee who requests time off for vaccination or ill after vaccination. That does not mean you can say you can't go first, but you can say if you're going to get vaccinated, you've got to bring back that card they filled out and gave you with proof of vaccination to show me that you actually did get vaccinated. You do not just have to accept their word on this, but it cannot be a barrier to their using time off. There's some policy questions that you need to think about. Time spent getting vaccine is considered hours worked under this law. And so if you're going to require vaccine, you need to think about it. And if all you're going to do is allow people to voluntarily get vaccinated, you still need to think about the impact on working time. It's an alternative to requiring vaccinations. You may think, and some employers are, providing rewards for employees who get vaccine. Why is this important? Well, we know that we had a tremendous amount of illness and absenteeism, particularly in the months of December, January, early February. Whether you think that this is a time that's past and we don't have to worry about it, I don't think it is. We still have the issue of how much, if we have 3,000 people a day in California who are being diagnosed with COVID, it's not an issue that we've resolved. The other part is requiring a vaccination does not give people the excuse not to wear masks at work, because the Cal OSHA rules still require masks even if vaccinated. Now, I've heard some discussion, and you probably have too, about why don't we just say if you've been given a vaccine, you don't have to wear masks anymore. Well, first of all, let me remind you the current controversy involving Johnson & Johnson's vaccine, where one person out of a million has been experiencing some blood clotting or after effects of the vaccine. The Pfizer and Moderna vaccines, which are also available, have a great effect, but are only 95% effective. That means instead of the Johnson & Johnson, where they're worried about one illness per million, 50,000 people per million could be unprotected by vaccine using Moderna or Pfizer. Now, we don't know this. We hope it gets better. We hope that we have what we call herd immunity. But it is not true that simply because someone's had a vaccine, they're excused from all wearing mask obligations or other social distancing rules. And as an employer, you need to know Cal OSHA is expecting you to require mask wearing and social distancing, which gets us to the Cal OSHA temporary standards. This is just a reminder, and at this point, we would hope that everyone is in compliance, that you've done a hazard assessment of your business and have a written COVID plan on the premise. The good news is this is not forever, but the standard is in effect until June 2021, and very likely could be extended because, as you've noticed, most of the other provisions that we're talking about today last until September 2021. I would anticipate the Cal OSHA emergency standards will be extended likely until September 2021 as well. Under Cal OSHA rules, a COVID case is someone with a positive test or diagnosed with workplace as a source of their illness. The rules on exposure are, if someone's exposed within 6 feet for more than 15 minutes, they've been exposed to COVID. Wearing a mask is not a prevention of that determination. And just a reminder, if you have 3 or more people in a 14-day period who report having a COVID case, there needs to be notice to the local Department of Public Health. You also need to offer testing to employees who are exposed. And to all employees who were exposed with the distance rule, the 6-foot rule, for more than 15 minutes, you need to offer testing. In Cal OSHA, for compliance, and Cal OSHA has put COVID enforcement as a priority and will either send a letter to an employer if there's a question, complaint, or issue, or make a physical inspection. We've had clients with physical COVID inspections now. You need to take a look at air circulation and to the extent you can increase outdoor air circulation. And if that's not possible, to take a look at your air filtration system. Number 2, look at social distancing, physical distancing, and mark it so it's clear, because that will help reinforce the success. Require masks for people who are other than working in a private office with a closed door, and have some method for reporting of employees who are sick, which could be, for example, and check in daily if people are ill, have temperature, but as time goes on, I think companies may be less willing to do that, but at least have some way for an employee who has COVID to tell you, because you need to know what rules to follow. And you also need to do a COVID hazard assessment. If at this point your firm has not done so, we would encourage you to do it. Our Cal Work Safety and HR team are available. We have performed hundreds of these, and we're happy to help you with that process. The other part is there are always lingering the potential for lawsuits and claims. And this is a repeat from last month's slide, but to remind you that one of the major concerns California employers have is what we call the Private Attorney General's Act, or PAGA. PAGA deputizes California employees to enforce the labor code, and essentially they become private attorney generals. If they sue you and get a penalty, the state gets 75% of the penalty, but the employee gets 25% for his bonus. But the employee's attorney gets paid separately in addition. And the penalty is $100, or most likely $100 per employee per pay period. So if you had 10 employees and you paid weekly, $100 times 10 employees every week for up to 3 years of exposure on various wage and hour laws would be great. Fortunately, under PAGA, there's a 1-year statute of limitation, but it's still a significant amount of money. This is a reminder that work from home creates a business expense that needs reimbursement. So employers must reimburse all necessary expenses or losses incurred by an employee in direct consequence of the discharge of their duties or obeying the directions of the employer. So the elements are: the employee made an expenditure or incurred a loss. Expenditures were incurred in direct consequence of the discharge of their duties, and they were necessary. So we have now lawsuits under PAGA under COVID rules. And the claims for reimbursement that have been indicated in those lawsuits are: for an employee working from home, the cost of their home internet service, the cost of their home telephone, their personal cell phone if it's used for business, the utilities in their home for cost for doing the business they're doing at home. If they had to acquire office furniture or computer equipment, etc., that's a reimbursable expense. Whether it's at home or away from home, if people are required to wear masks, that's a reimbursable expense if the employer doesn't provide masks, or gloves, or even hand sanitizer. So these are real lawsuits that employees are claiming now, and you should not be surprised, and think about how you're going to handle it. The key is that this covers reasonable costs, which must be reimbursed even if the employee would have incurred the same expense without using the item for business. So home internet, you'd say, well, you had home internet. Utilities, you say, well, you had utilities. That doesn't matter. That's not an excuse for reimbursement. So the only way to do this is to come up with some policy, either a flat amount per month or per week, or a policy where employees can apply for reimbursement by giving you an expense request, reimbursement request, which they document and support what their claims are. And this is just a reminder that the rule for a number of years now, employees who use a personal cell phone for business have to be paid a reasonable percentage of their cell phone bills when they have to use their personal cell phones for business. So what should be included in your working from home reimbursement policy, for example? You'd say you'd want them to require an agreement, have an agreement, because otherwise, how do you know what the terms are, and how does the employee know what the terms are? You can ask the employee what they already have, and then not have to acquire new things that they already have, and also that they can't acquire it or replace it without approval. What do the employees need? What is necessary? So if employees are saying they need these various items, have a space on your agreement to list what it is that's being covered. Document why you're paying it. Also, how do they submit the request, or how do you pay them? What if they have a problem that is inadequate in the payment and is not enough? And so this is just things to think about. And we do have suggested work from home policies that help with these issues. Just a reminder that CalWorks Safety and HR's team is here to help you. And because of these areas, for example, that you may not have thought about in wage and hour issues, it may make sense now or as your business expands, as the community reopens, to do a quick HR audit and make sure that your ducks are in a row, that you have dotted the I's and crossed the T's. I can tell you, working with personal clients in the last 3 weeks, we've had clients who weren't aware that they were supposed to do certain things that have been in the wage and hour laws for years, but never became a problem. But now they had an employee who left, who asked for their pay records and their personnel file. And we're looking through that and saying, we're trying to, after the fact, catch up and deal with issues that could create liability for your company. Why not get ahead of that curve and do an HR audit now and make sure that your practices are appropriate? You also, if you have not updated your employee handbook and policies, this is a great time to do that. The California legislature will be doing new laws, and the federal government will be coming out with new laws, just as you've seen in the last month. But if you have a current, well-done employee handbook, you have a good platform to go forward on. If you haven't conducted a COVID hazard inspection and a written plan, we can help you with that, and you should do that. Another thing to keep in mind, and we're noticing a lot of employees are very nervous and anxious about a lot of issues these days. It may make sense to think about interviewing employees or having a way to identify their concerns and problems before it becomes a complaint, before they leave and sue you, things when they're still working. So we can assist you with employee morale or mood surveys or stay on the job surveys or engagement surveys. So these are issues, knowing what your employees think is a critical component for a successful program. Also, a reminder, if you have 5 or more employees, you're required to do sexual harassment training of all employees of 1 hour. And the deadline for that was December of 2020, but there had not been any penalties expressed. So don't let time go on, and plan and schedule sexual harassment training and a 2-hour training for your supervisors and managers. The training is required every 2 years. For new hires, it's required within 6 months of their starting to work for you, or even a shorter time if they're temporary or staffing service employees. So these are just things that we can here to do to help you. To give you an idea of what's coming up, there's a new program that's expanding in California called Cal Savers, which is a requirement. If you don't have a pension plan, a 401k, or similar retirement plan for your employees, you must offer this state-run Cal Savers program. It's been phased in for over the last several years. Last year, July of 2020, it was extended to employers with 104 employees. This July, it applies to employers with 50 or more employees. And a year from now, in July of 2022, employers with 25 or more employees will have to provide. We're going to have a program at 10 a.m. on May 20th about Cal Savers, and also about options that are available to employers as an alternative for compliance with Cal Savers that might be better for their employees and for their operations. By the way, even if you only have 2 or 3 employees, you can voluntarily participate in Cal Savers. But we would like to make sure people know what's involved with Cal Savers and the details, and that'll be our program in May. And then on the 3rd Thursday of June 17th at 10 a.m., we're going to talk about the legal steps and details in compliance with actions on employee termination. Many people you fire, quit, laid off, and so on. It's very important that you follow the process and protect yourself. And that's one of the key vulnerable times in dealing with employees is termination. So we'll be talking about that. And Wendy Garcia of our team will be leading that program on June 17th. We're here to help you. We will be posting the recording of this workshop on our YouTube channel. It may take us until Monday of next week, but it will be posted. And if you send us an email, we're happy to send you a copy of the PowerPoint. So with that, if there are any questions, I'm more than happy to address them.
Perfect. Just a couple questions here. Can you tell me if an employer that has only 20 employees but has an employee that needs to care for a family member due to COVID, are they still able to utilize CFRA, FMLA, and or AB 1867? Or has this expired for them but not for employees who have requested FMLA COVID relief prior to March 31st?
Okay, so for people who currently need help, first of all, you can voluntarily apply the FFCRA American Recovery Plan provisions, even though you have only a couple of employees. If you have less than 5 employees, you're not covered by the California Family Rights Act, which includes family leave for caring for family members, nor are you covered by the federal FMLA. So one of the things, and one of the things that's critical, we published for our team a list. There are over 40 federal and state laws that govern employment, and the application of these laws differ by how many employees you have. So if there are any questions and you're a small employer, I suggest you contact us and let us just review with you all of the laws that you are covered by, so you have an awareness of that. But in your specific case, you can voluntarily use the benefits of the federal law for emergency paid sick leave to care for family members. If you wanted, you're not required to. And you're also not, if you're under 5 employees, you're not covered by California or federal leave laws for this provision.
We decided to give each person 3 hours pay for each vaccine appointment as a generous gesture. Any issues that you can see with that? We have more than 25 employees.
I think that's a great thing to do, and it's going to be more than ample for almost everyone. Just be aware if an employee came to you and said, here's why I couldn't get it done in 3 hours, that you're listening to them, because the statute doesn't have a number of hours limitation. But there's also a small likelihood that somebody had some issue which required them to extend longer than 3 hours. But I congratulate you on being positive about it and getting ahead of the curve. And those of us that have dealt with absenteeism during these COVID period are probably thinking that anything we can do to promote vaccination is going to promote productivity and employee effectiveness.
The time spent getting a vaccine is considered hours worked only if we required or mandate it. Is this correct?
That's right. It's if you allow employees to operate, but there is the provision SB 95. So if you have more than 25 employees, then they're entitled to time for vaccine. So this is one of those areas that's why this is also frustrating. You have to know which law applies to you and which rule to follow. So even people who voluntarily get vaccines are entitled to time off under SB 95 or the special paid sick leave law that took effect retroactive to January, but effective April 1st. And that's good until the end of September.
How will we, the employer, be getting billed for the cobra premiums? Would this come from our cobra administrator?
The fact is you're probably not going to get billed from cobra premiums, because the cobra premiums should be being sent directly to the employee. And then the notice that's given the employee, it tells them where to pay. So what you need to do if you've got employees in that situation is look to whoever handles cobra administration for you, which could be somebody in your own office, or it could be an insurance agent or some payroll firm that handles the cobra administration, and discuss with them, do we have any employees that this applies to, and what do we need to do, because you do need to give them notice. You'll send the premium to the regular vendor because it's coverage effectively under your group plan, but paid for by the employee. But you're likely not to get the invoice unless you arrange to ask for it with your employees.
Great. So if we don't have any more questions, if you would like a copy of the slides presented today, send an email to info@calworksafetyhr.com. If you have any questions, same thing. Again, be on the lookout for future topics on our website at calworksafetyhr.com. Thank you. Stay safe, healthy, and have a wonderful day.